April Zanis, and together with Dan Bemmel, we are the chairs of the BHBA Family Law section. We are very excited to bring you a conversation with the former Chief Justice of the California Supreme Court, Anne Anthony Storm. Chief Justice Tani Cantil-Sakauye joined ADR Services in 2023 after a distinguished career as the 28th Chief Justice of California. A native of Sacramento, she earned her JD from UC Davis School of Law and began her legal career as a deputy district attorney with 32 years of service on California's appellate and trial courts. She was appointed by 3 governors, starting with her role on the Sacramento Municipal Court in 1990. Throughout her tenure, Chief Justice Cantil-Sakauye emphasized transparency and civic learning, leading initiatives to inform Californians about the judiciary. Anthony Storm is the founding partner of Storm Palyan, specializing in electronic security issues related to high-profile divorces. He safeguards private information for public figures and minimizes harm from potential disclosures. Prior to entering family law, he clerked for the U.S. Attorney's Office, where he received awards for outstanding service. Anthony has authored articles on family law, including a notable piece on representing individuals with notoriety, and he regularly lectures on various family law topics. We hope you enjoy their conversation.
Thank you, April, for that wonderful introduction. It's much appreciated. Great quote from the last panel. I couldn't agree more with the citation that said successful appellate practice begins at the trial court. The trial court are the building materials for the appeal. It is a foundation of all of your legal arguments. And when you miss a beat at the trial court, sometimes you can't go back. The follow-up quote that said if it wasn't in the record, it doesn't exist, couldn't be more true. I'd also like to thank all the judges and attorneys who are participating in this program for their time and effort. It's a wonderful program. Special thank you as well to Dan Bemmel and April Zanis for steering the ship here. We're going to have a great fireside chat with Justice Tani Cantil-Sakauye. As we just heard from April, Justice Cantil-Sakauye has done it all. You were a DA, Chief Justice, more than 3 decades on the bench, appointed by 3 governors, Deukmejian, Wilson, and Schwarzenegger. You started at the municipal court level in around 1990, moved up to the Superior Court in 1997, did criminal and civil assignments, and at that time established something that I think is near and dear to most of the viewers here, which is a specific domestic violence court in Sacramento. In 2005, you moved to the Court of Appeal of the 3rd District. Right now, you are CEO and president of the Public Policy Institute of California, where you hold the Walter and Esther Hewlett Chair in Understanding California's Future, as well as you're part of ADR Services, where amongst other things, you handle mediations, case evaluations, mock trials, and act as a special master. We've spoken once before. I've had the opportunity to sit and watch you preside over Supreme Court matters. It's always been my impression that you conduct yourself with integrity, honesty, and you're a person of great moral character. We're very thankful to have you here. I know you're a Sacramento native. We chatted briefly about that. I mentioned before it's a special place for me. I went to law school about a mile away from where you went to high school. My eldest daughter was born in Sacramento, a couple blocks from the state capitol while I was clerking for the U.S. Attorney's Office. And it's really, really a wonderful opportunity, and we are honored to have you here at the 50th anniversary of this program. So thank you very much for participating.
Thank you, Anthony, and thank you to the BHBA for inviting me. When it took time for me to register with the Bar Association, I looked who had the best MCLE, and I registered as a member of BHBA. Out of all of the different bar associations I could have selected, I looked at your menu. So thank you, and thank you to April and to Dan for making this happen.
So We've talked about all of your great experience, and it's very rare. In fact, I know of nobody else who's sat on all levels of the court, municipal court, you were a DA, so much different litigation experience, sitting on both sides of the fences. I imagine preparing for a case at all those different levels is completely different. In your experience, what did you see as the biggest difference in adjudicating matters at each level?
Thank you, Anthony. That's a really good question because each level requires the judicial officer to bring a different set of skills and statutory construction. And so I will say at the trial court, the different skills that a judge needs to bring, frankly, is to clear the decks, to allow the attorneys to do the best they can in the arena, and let the attorneys try their case. So in other words, get all of the heavy lifting out of the way for the judge. That is all the motions in limine, all the anticipated questions, all the nuts and bolts, so that the attorneys aren't distracted, so that the judge isn't distracted. So there are very few surprises, few interruptions, and making sure that an understanding as a trial judge that I need to let people make their record, and I want the attorneys to make their record, especially in those instances where the attorneys are denied or are limited. Offers of proof are very important, as you know, as an appellate specialist. And so it is really important that this record and the judge sort of stay out of the way and let it happen, and also allow the attorneys to speak to sidebars on the record when they aren't recorded, or a summary of what happens in chambers when they aren't recorded, because the appellate court really wants to know, and more appellate justices who don't have a trial background, they need that context. At the appellate level, very different. We're reading the book. And as you so eloquently put it earlier, if it's not in the record, it didn't happen, even though we know something happened, even though we know it happened, but we are not allowed to review that or talk to our colleagues about that. And at the appellate level, we keep in mind that we follow the rule of law, we follow all of the precedent, we follow our different colleagues' analyses if we agree with them, but they're not otherwise binding. The conflict amongst the appellate courts and the divisions therein are what makes for important Supreme Court review. At the appellate level, the appellate justice has to be thinking, I'm writing so my Supreme Court colleagues can understand fully where I am on the standard of review, why I have phrased my analysis in this way. I'm speaking frankly to the court so they better understand what my work was at the Court of Appeal. And also this is an opportunity for the appellate justice to be able to invite the attorneys to do supplemental briefing and new cases, and to ensure that what's before the Court of Appeal at that time that it's being litigated is truly the state of the art that we know it, to make the best kind of case possible, because very likely there'll be a petition for review out of that particular litigation. And at the Supreme Court, that's a whole new ballgame, because now there are 7 different law offices with very different business models, very different backgrounds, looking and very different geographical backgrounds, diversity backgrounds, age backgrounds, practice backgrounds. And so we very often at the Supreme Court start from scratch because we don't assume the knowledge that we have is homogeneous, and it's not. So this is where we have to be very patient, very collaborative, take our time, allow all arguments to develop, and to be really civil and respectful with one another, because we are supposed to disagree, and we're going to handle a lot of cases that we hope will shape the law.
You talked about the importance of making your record, having offers and proof, making sure everything is recorded. Right now, there is a huge access to justice issue. There are not enough court reporters. It's in our last panel, one of the panelists said it's almost impossible in her experience to get a settled statement. So what sort of opportunities might there be for these litigants who can't afford a court reporter, who don't know the local rules about requesting that the hearing be recorded, which is a relatively new thing we have in family court and LA Superior Court. What in your mind can be done to alleviate this problem with people who don't know and maybe can't even afford to bring their own court reporter?
You have really touched upon an access to justice issue that existed long before this chronic shortage of court reporters that we've read about in the last 4 years. Because family law, at least even when I was on the trial court back in the 1990s for 14 years, suffered from an inability to have court reporters in the family courtrooms because they were used elsewhere by way of statutory priority for some criminal and otherwise civil. And it was very, very difficult. That's only exacerbated over time with family law judges having to write their own records and heavy caseloads without a recording. And many, many times I have spoken to the legislature and to Governor Brown and to Governor Newsom that this is the most critical piece of access, because family law is about families and children and support. And we must have a record, because on appeal, as all of you know, the judgment is presumed correct. And it is the appellant's role to prove error. And without a record, we will assume there was no error. Even when I was on the Court of Appeal, there were virtually few records out of family law courts. And so we would basically have to either dismiss or affirm. And that really puts people who have no control over this, because court reporters at one point were all staffed in the courts, but they became court employees, but they still had a fair amount of freedom. And so now the system has become acute, because now we have just a shortage. We don't have enough bodies. All of us are aware of the different counties, and especially, let's just say LA, where we are with this bar association, that put out signing bonuses, that pleaded with people to please come and be a court reporter. And we know that that was to no avail. And I think Los Angeles boldly did the right thing, as you referred to with that order and that rule, Anthony, and that is to allow people to make their own record. Because I think that that kind of argument will be sympathetic and persuasive to courts of appeal, who are all aware that our hands are tied. We can't encourage any particular profession. We tell and ask and plead with the governor's office and the unions, but there's just no more bodies becoming court reporters. And the truth is, across the country, they have turned to technology in lieu of court reporters, although court reporters have been re-engineered for different purposes to make a record, but they're not taking a verbatim. And we also know all court reporters have always recorded the work that they're doing as backup. So I think it's an incredible fiction to say there's any due process lost by not having a court reporter. But I do think we have to push the envelope. The envelope has to be pushed by innovative ways, because I think those kinds of arguments that get to the Court of Appeal, as to that panelist who said, I can't get a settled statement, so you find some way to get a settled statement, whether you record it on your cell phone, but you make that argument. That's the argument that the Courts of Appeal will resonate. They will speak to it, and it will catch the attention of the Supreme Court. Rules will change. Judges will write to it. It's still, though, it's going to be a problem. We have to change the technology. There's no other question. Other states have done it. California just has a strong union hold. I could go into some terrible stories about that, but the truth is, it is about jobs and labor, and it's changing. It has to change.
Well, you have such unique experience in navigating between the judicial branch and intersecting with the government, getting these issues accomplished and challenges overcome, like these court reporter issues. Talked about technology and how that can help things. I guess the one positive thing that may have come from the pandemic is the pushing for the courts to adopt so many new technologies. We had remote appearances come, e-filing, document management, document sharing. There are obstacles balancing budget needs and adopting technology. Artificial intelligence, for example, is now in its infancy, but progressing at an extremely astounding pace. In terms of technology, what do you see as the future of the court?
Thank you, Anthony. That's what people have to know as a baseline when we talk technology in the court, is that prior to the pandemic, there were a number of legislative statutes that prohibited the court from using technology. So much so that we had to report every year to the legislature what technological devices we were purchasing. because they didn't trust us not to use technology. And the reason they didn't want us to use technology, I'll just be clear, and I can speak as a retired, is that because there was concern it would take over jobs. So mark that, because that's the same argument over AI. But let me say what happened is, while we were within these constraints where we were prohibited by law from electronically recording felonies and some civil and all civil, we found out that during the pandemic, when everything turned around and upside down, the governor gave me, as the Chief Justice, and the Judicial Council the power to suspend statute in an executive order. This power to suspend statute allowed me and the Judicial Council to lift all of those prohibitions. So we immediately went into remote appearances, remote arraignments, as much remote and hybrid that we could encourage, because we didn't want to bring people into the courts. We didn't want to bring jail populations into the courts. We didn't want to have the transportation. We didn't know how the virus was spreading. We have a lot of vulnerable populations in the courts. We just didn't want the spread to be a super spreader. So we were very innovative in COVID, because I and the Judicial Council suspended as many statutes as we could to allow remote access. Thereafter, when there was a concern whether or not, by suspending trials and suspending hearings and blowing the 3-year rule and blowing the 5-year rule, whether or not there'd be litigation over all of those actions taken in that emergency, a senator came in and asked me, a lawyer, and she said, "What do you need to legitimize everything you did during the pandemic?" So she wrote a statute that legitimized all of our actions. It also was the proving ground, as Anthony has referenced, for the court to begin even greater, more systemized, normalized technological use, which you're seeing now. There's still a fair amount of distrust, as the legislation is, the remote access legislation has a sunset date, has a pilot. I have said to the governor before I left, we've had 3 years of pilot. What more do you need? It's an option. It's not a requirement. It's cleared caseloads. It's made things more accessible. I don't know that you can point to a single negative. And so it continues to be a struggle. Now the new monster on the block, so to speak, is AI, because AI is, as you pointed out, Anthony, it's growing. No one knows what it is. All we can do at this point with AI is to provide guidelines and also ethical rules around its use, because it's changing so rapidly. In my role as the president of the Public Policy Institute of California, we're a think tank. And so I'm putting together a group of researchers and PhDs to come up with ethical guidelines that researchers can and cannot use in purposes of AI. But all of us have used AI, and AI is a great starting point for our work. It's just not the end point for our work. And the people I trust the most with AI, frankly, are lawyers, because lawyers are critical thinkers. Lawyers will question the source. They'll run it down. They'll find out if it's true. They'll find out if it's still true. That critical thinking has to be, I think, really spread across all users. But no question, AI is confounding all disciplines. It's going to be, as you all know, a huge disruptor of knowledge professions, which is new to all of us. It can never supplant, it can never be the end all, because it is generative. It's looking off of the World Wide Web, but we have to be in control of it. And we have to make sure that it's not being abused. And that's going to be the role of the attorneys, who are boots on the ground with the use of AI in practice by their clients, in business, and in court.
We're certainly entering a new era of technologies, and I'm sort of a technology guy. I follow everything. I love it. I adopt everything and see how it works. And I'm certainly looking forward to some of the efficiencies it might create in both of our practices and on the bench. You briefly touched before on family law and the importance of the record. One really clear thing everybody in this audience knows that I think is one of the most important and core examples of the California Constitution and the US Constitution is the statement, "We the people." It's maybe perhaps to me, the most personal statement in the Constitution. Courts are the arm of the government that establish justice for the people. Family law, being very special and very personal, You talked about the importance of having a record. It's more than just a collection of courtrooms. You get to know families. You get to work on fixing relationships. You help victims of domestic violence. I think family law attorneys really, really do some good. It's something that's really close and important to me. I also surmise, given your involvement with domestic violence issues, that you share this belief. We see, with that in mind, we see that there's a right to counsel in criminal actions. But nothing that I see is perhaps more fundamental and personal to people are litigating their family law issues. So many litigants seem to be lost in the process and without the availability and the ability to afford counsel. Do you have any insight on anything that can be done to improve this issue?
You have put your finger again on a really critical, long-standing challenge in the judiciary and in the legal profession. We always point to family law when the statistic comes up that over 3/4 of civil cases have at least one party unrepresented. We also know that when we train new judges who typically go into family law as a first assignment in many courts, that the population of pro per can be anywhere from 70 to 80%. And you're absolutely right. Knowing that the United States Constitution, the California Constitution, has recognized that families and parenthood and parenting is a basic right, a fundamental right, entitled to greater due process than other rights. It's significant that we do not provide that kind of counsel. We do provide, the courts have provided, and we have run pilot programs like the Civil Gideon Project, which does in some counties, we have funding, and it's over now probably 15 years old, where we do provide counsel, or we provide an organization that provides assistance to support the pro se party in court. We do a number, and I'm not saying this is in any way sufficient, and I'm not saying because the gold standard is a lawyer on the other side in a family law case. That's the gold standard. The gold standard is something we have never been able to meet. So we have a lot of piecemeal efforts. We have AmeriCorps. We have kiosks. We have training. We have bots that can walk you through the process. We have and train the new judges and the judges in family law to be better prepared to work more patiently with pro pers, to use the time wisely so these hearings don't have to be continued and repeated. We have made a number of efforts. None of them are sufficient. We've gone to the state bar on numerous times to ask for pro bono work, to ask for support. And they also mean well, but when it comes to getting something like this passed before the State Bar Board of Trustees, which for some period of time in my administration were elected, now they're basically appointed. It's a difficult challenge. People have very strong emotions about changes in family law. The lawyers, the different groups that are interested. When I ran the Judicial Council, the public policy arm of the judiciary of the third branch, we had public comment. Public comment at every single meeting was family law litigants. There was never negligence litigants. There were never breach of contract litigants. There were always people who had been through family law and who felt that somehow, some way, the judge had shafted them. It was a constant. And we took it to the legislature, and we found a legislator who had a hearing about what can we do in this area about representation. And it still eludes us. But I think you're absolutely right about recognizing that court-appointed counsel with the appropriate funding ought to be permitted, ought to be encouraged, ought to be piloted somewhere. But we have tried a lot of little programs that still aren't doing justice to it. And you've pointed out a perennial problem.
Thank you. That's really insightful answer, and I appreciate all those insights. You also spoke about lawyers' ability to reason when discussing technology. How does a bench officer look at each issue to help think about and resolve those problems that are before it?
Well, a bench officer under the ex parte rule, has to be very careful, because the bench officer can only look at the briefing and what's submitted as part of the briefing or as in evidence. So if we were to look at the canons and the ethical rules pretty strictly, I'm not supposed to go on the internet to know, what a hydraulic lift looks like in the litigation that I'm trying to figure out. So someone was injured. What does that even look like to me? I have no idea. So even when I go online to look at it, I feel a little, I probably shouldn't be doing this because it's not in the record. So historically, judges at all levels of bench, like humans, there are some early adopters like yourself, and there's others who abhor technology, never want to learn it, don't want to figure it out, hate it, and find every reason to avoid it. Now, I would like to say that those dinosaurs are retiring and we have a new crop coming in and they're used to technology. So we'll see technology pick up speed with users who are used to it and demand it as judges. But I was this is dating myself, but I was on the court when computers were introduced to individual chambers. And judges were like, I'm not touching that. It sat Chief Justice Ron George, a man I love and respect. When I walked into his office to take over, his computer was in a corner, unplugged, facing the wall, down near his bathroom. He never used that thing. So we are getting and changing the hearts and souls and minds of new judges, but they are constrained. They are not supposed to go outside the record looking for things when it comes to briefings.
With that in mind, I mean, everything that we present the court is their world to view these cases with. What can we do as attorneys to better prepare both for litigation and mediation? There's obvious things, of course, like exchange briefs, but
sure. Well, let me start with mediation, because in mediation, maybe you don't have to go to the mat if you think there's a chance that it might resolve because you have done enough discovery to know that there's leverage on each side. So the best case for mediation prepared by the attorneys is to know the case and to know the weaknesses of your case and to know, therefore, why it is you might be open to some kind of agreement. Also, in mediation, it's really important for the attorneys to prepare their client for that different kind of setting. It is a place to talk, to be heard, to try to resolve. It's not a place to stand on your binary rights and how right you are on the law and how you know you're going to get this ruling, because you don't know that. But a lot of clients are not prepared. An attorney needs to prepare. Litigation is, you have to be prepared, think like your opposition. You need to prepare like your opposition, and you need to prepare to your weak spots. And some of those weak spots, it depends on the nature, has to be disclosed to the court in full disclosure. But it is about preparation. That's why an attorney's job is so hard and so long. It takes a long time.
What advice would you give to new attorneys who are just coming into the practice of law?
I would say to new attorneys first that you develop really strong, healthy habits, not only about taking care of yourself and your family, but also about how you work. I think that you need to set boundaries, but just to be clear here, you're going to work on the weekends and you're going to work at night if you expect to be successful, whether you're in private sector or public sector. Also, to the extent that you can, keep a record of your research so that you don't have to reinvent the rule every time something comes up in a summary judgment motion that you think you heard about. Attend CLEs. Attend as much as you can, even if it's not on your subject area. Listen and get to know and find out what the other areas of law are. New attorneys, you should join things. You need to network. You need to find out how other attorneys are operating, job operations, different modes of appearances in different courts. And I think if you ever think you want to go to the bench, you need to start keeping a strong record of your cases, keeping it updated, because if you do ever decide to try to get appointed, you're going to have to fill out like a 30-page single-space application that's going to ask you everything about your practice, and you want to be able to answer that. So it is about keeping a record. It's about being prepared. It's about committing to working hard.
Well, that's great advice. I wish I've done some of those things in my practice. I've always created a record of everything I've done. I think that's really important for new attorneys to do. Do you have a particular vision for the future of the courts?
Yes, I think that the vision of the courts is that we are going to have more options that are more streamlined, that are in greater and plainer English, that we will reconsider I think, some statewide rules that seem, and just do a vetting of those rules with the different attorney groups to find out whether or not they're still relevant and useful. I think we can look to other states that have gone, for example, fully remote and fully automatic tech in courtrooms where there aren't court reporters, but there is a record, and that record can now be accessed on appeal in a really exciting way. The trial court record can be used on the appellate court by actually clicking in on the link and actually hearing the testimony. There's a number of things I think technology is going to bring us, but it's going to bring us efficiency. We have to be careful because we don't want to lose the human touch. We still, that is the nature of law, is our ability to be and work in conflict, but do so civilly. But I think technology is really going to change the court, and the court needs to be aware of it because that's what the public will demand.
I thank you so much, Your Honor. I mean, I thought this was a fascinating program, discussed the intersection of the judicial branch and government, integration of technology in the court, and what we as litigants can do better. I found so much value in this program. I very, very much appreciate you coming today. I wish we had so much more time because there's so many more things I could ask. And it truly, truly was an honor to have this opportunity. Thank you.
Thank you, Anthony. I appreciate it. I also still remember your case in front of the California Supreme Court. Won't mention it, but I think you did win. So there you go. Thank you. It was a pleasure.
Your Honor.
Bye.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.